After the restraining orders are filled out and filed with the judge, they need to be delivered or given to the other party you want restrained. Giving the papers to the other party tells them the orders you are asking for, the hearing date, and how they can respond. This is called service, and in restraining order cases, service, or giving the papers to the other party, must be in person, or personal service. In this case, you are giving them the packet of forms you got back from the court clerk. These forms must all be served in person. They cannot be served by mail. You, and no one else protected by the orders, can be the person giving the papers to the restrained person. It must be done by someone else, such as a friend or relative, who is over the age of 18. You can also contact the sheriff's office to have them serve the papers for you. The sheriff's office will do it for free. Or you can pay a professional process service company to deliver the papers for you. Until the papers are served, the police cannot arrest anyone for violating the restraining order. Also, the judge cannot make the orders permanent unless the restrained party received the papers. When having a friend or relative serve the papers, ask them to walk up to the person they are serving. Make sure it is the right person. Ask for their name. Give the person copies of all the papers you received back from the court. The person serving the papers then fills out, dates, and signs Form DV-200, Proof of Personal Service. The person serving the papers then returns Form DV-200 to you. If the restrained party won't take the papers from the person serving them, don't worry. Just leave the papers near the restrained party. When do I have to deliver the papers to the other party? To figure out the deadline for when the papers must be given to the restrained person, pull out Form DV-109 you received back from the court and look at the hearing date on page 1, number 3, and see the date set for your hearing. The court wants the other party to receive the papers 5 calendar days before that date. Remember, law enforcement does not consider your order is in effect until the other party received the papers and the proof of service is filed with the court. Now, what if you cannot serve the papers before the last date? If you find you cannot serve the forms before the hearing, you must go back before the judge and ask to move the date of the hearing to give you more time to serve the papers. If you just have not been able to do it before the date required by the judge, you need to fill out and file the following forms to the clerk's office. Form DV-115, Request to Continue Hearing, and Form DV-116, Order on Request to Continue Hearing. These forms ask the judge for a new hearing date and to extend the deadline on the temporary orders you received until that new date. You must attach copies of these new forms, DV-115 and DV-116, to the copy of the original orders you have, and then serve the entire package on the other party. Or, instead of filling out and filing these forms with the clerk, you can go to the hearing and request a continuance from the judge so you have more time to complete service of the papers on the other party. You can also go to the Self-Help Center before your hearing and ask them for help. Now, service is done. What do you do with the completed Proof of Personal Service Form DV-200? Bring a copy of the original signed proof of service with you to your hearing. Also, as soon as possible, file the original signed proof of service Form DV-200 with the court. If you could not file it with the court, bring the original also with you to your hearing. Again, remember, the restraining order is not in effect until the other party receives it and the proof of service is filed back with the court clerk. If the sheriff serves the orders, the sheriff will send their own proof of service to the court for you. If the other party is avoiding service of the papers, consult an attorney or contact the Restraining Order Self-Help Center at 408-534-5600. This is very important. Always keep an extra copy of the restraining orders with you for your safety. Put copies of the restraining orders in your car, in your purse, with your apartment or building security or manager, at your child's daycare center or school if the restraining order includes your child. Also, give a copy of the restraining order to any other protected party. Should you call the police if the restraining order is violated? Yes. Always call the police if you feel the order is being violated. Sometimes an abuser must have the police called on them a couple of times for them to understand that this order is important and they can no longer abuse you. On the other hand, unless there is property damage or physical harm, every violation of the restraining order does not mean an automatic arrest. But you should still call the police. This helps to build your case about why the restraining order is necessary and to help keep it in effect for a longer time. You can call the police or the Family Violence Center at 408-277-3700. Call the police about a violation even if you haven't had a chance to serve the order yet, but the abuser violates it. When the police officer arrives, show the officer a copy of the restraining orders. The officer can serve the order and then enforce it at the same time. If this happens, the police officer will send the proof of service to the court for you. If you believe the restraining order is violated, you should also write down what happened, when, where, and who was there. Take photos of property damage or physical injuries. Save call logs, messages, voicemails, emails, social media posts, text messages. Save everything. Don't delete. When the police arrive, show them a copy of your restraining order. It is a crime for the restrained party to disobey the court's order. The restrained person can be arrested, fined, or sent to jail for violating the court's order.